The Nonhuman Rights Project has been working with IEET for a year or so to make it come true. It looks like it is coming true. So I'm very, very happy to be here. Indeed, the Nonhuman Rights Project has been very active over the last days and months and years after, for me, 28 years of preparing for this week, and for the Nonhuman Rights Project, certainly the last 7 years, and for the last a year of intense preparation to file the first lawsuits in which we demand legal personhood and a fundamental right to bodily liberty for a non-human animal, which are 4 chimpanzees scattered throughout the state of New York. But lest I have to plagiarize from my talk tomorrow, I'll probably keep that short. I'm looking forward to seeing you all, speaking to you all. Please come up and speak to me. And Natalie Prosen, where are you, Natalie? Please come up and speak to us. We'd very much like to speak to everyone here. And finally, I'd like to say I'm so happy to see Peter Singer. Peter, when both of us had, well, when I have more hair than Peter now, but when our hair was a lot darker than it is now, I think I met Peter when I was 31, and now I'm 62, though I only look 61. And Peter is responsible for me standing up here. In 1980, someone handed me a copy of his book, and I read it, and it showed the power of writing. When I started reading the book, I had no idea about animal rights. When I finished it, I went to my law partner. I said, I have good news and I have some bad news. We're going to continue to practice law, but I want to be an animal rights lawyer. And that's what I became, and it's because of Peter's work, for which I'm forever grateful. So talk to you soon and speak to you tomorrow. As I was just telling someone, I've practiced what I call animal slave law since 1981. And for the first time, I stood up in a courtroom as an animal rights lawyer, and I was so delighted. We'll be posting our transcript, which includes the judge repeatedly telling me to shut up and sit down, and finally saying he didn't say shut up, he just said stop talking. And he finally told me to sit down because he said, if you sit down, maybe you will stop talking. I've been waiting 31 years for this, Judge. So we had a lot to say. So this is actually, this is our petition for writ of habeas corpus. Right here, there are literally thousands of hours of work that have gone into this. And this is our 80-page memorandum in support of our petition for a writ of habeas corpus. So sometimes this reminds me of the joke I sometimes tell, which is what happens when you cross a lawyer with the Godfather. You get an offer you can't understand. So you look at these things, you're saying, I hope I can understand what's going on, and we hope the judges understand. But part of my job as a lawyer is to convert what may seem inscrutable and ununderstandable, both to judges and then especially to the media of the world, which has shocked us how interested the media have been in the work we've done. We've given interviews all over the world, and people are sending us emails saying, I heard you in Australia, I heard you in Poland, I heard you in London, in Russia. We had a Russian film crew following us around in Long Island. And so there's just been a huge amount of interest, which makes us feel more confident that perhaps the time has come. Timing is everything. And I remember I've often read a short story by Stephen Vincent Benet where he situates Napoleon Bonaparte 50 years before he was born. And the man thinks the same thing, he wants the same thing, but nobody around him cares. And so he dies a kind of an angry and bitter person that not only does he not have world domination, he can't even get off the island where he is. No one cares about him. And so those of us in the Nonhuman Rights Project have cared about this, and I certainly personally have been waiting decade after decade for the time that we thought was the earliest possible moment in which we had some reasonable chance of winning ultimately. And so I started this thinking about this and actually planning for this week in 1985, where I set myself a 30-year plan for attaining legal personhood for non-human animals, because at that time there was hardly anything at all. There were no classes being taught, there were no textbooks in law schools, there were no law reviews, people didn't talk about it. People on occasion barked when I walked into a courtroom, and it was all either ugly or non-existent. So I and many other lawyers now, have worked steadily to try to bring our legal theories, as well as the facts that support them. And Laurie Marino will be talking about those. The ever accumulating facts that scientists find that tell the world, in our case, what chimpanzees are, who they are. And Laurie will also show that a substantial amount of our petition are affidavits from 9 of the most prominent primatologists in the world. We have affidavits from scientists in Japan, in Sweden, in Germany, in Scotland, in England, and throughout the United States, where they very carefully talk about what they've seen over 20 or 30 or 40 or almost 50 years of work with chimpanzees, both in captivity and in the wild, and focused on what we asked them to focus on, which is the issue of autonomy. Because as I'm about to explain why we think that is very important. So they did a terrific job. From any lawyers out there will or may appreciate the problems we had in order to get an affidavit into evidence in a New York court from a foreign country is something that is a sight to behold. And so we either have to follow these Byzantine arcane rules of the New York courts, or we have to invoke an international treaty. And we actually invoked an international treaty. And lawyers from all over the world stepped up to help us and get it in a timely way. And so we certainly appreciated the work of the foreign notaries and the foreign officials. We're still waiting for the original to come from India for one of our signatories, and we have a copy of it. We still don't have the original, and one day it'll show up, I hope. So within this, what we're asking, we have filed 3 petitions for a common law writ of habeas corpus. And habeas corpus is Latin for produce the body, and it's one of the most fundamental legal claims of action that exists. It's one of the oldest ones because it protects one of the oldest recognized and most fundamental interests of human beings, which is the right to bodily liberty. The folks who we deprive of bodily liberty are people who have committed crimes, and we sentence them to jail. And that's what we've done to chimpanzees and other non-human animals. We put them in an everlasting jail. And the writ of habeas corpus has been used across the centuries in English-speaking countries, for the purpose of demanding that the jailer produce the body of the jailed and give it a legally sufficient reason why the jailer is keeping the prisoner in jail. And one of the most famous cases was one that I actually wrote a book about called Though the Heavens May Fall. And it's a case that we followed very carefully. It's called Somerset versus Stuart. It was a 1772 case in which a slave named James Somerset, who had been enslaved for 25 years, first in the US and then in London. And in 1771, he left his master, the man he'd been with since he had been kidnapped as a slave from West Africa, and he'd been taken across the Atlantic crossing and had been sold to Charles Stuart in Virginia. And Charles Stuart had taken this young boy throughout the United States as Stuart began to rise through the ranks of the British company that dealt with customs, and he came to be the highest ranking official in North America. And James Somerset was able to spend time in in pre-revolutionary Boston, he certainly would have seen Samuel Adams or heard of Samuel Adams, maybe John Adams, and could really feel the ferment that was going on there. And so in 1771, Charles Stuart took him to London. And it appeared that James Somerset began to plot his escape. And one thing he did is he converted to Christianity, because he and many other enslaved blacks, against all evidence, believed that one Christian would not enslave another. So, but a side benefit is he got godparents. And it was kind of known that the duties of a godparent was to help an escaped slave live. And so he duly escaped, and something happened between him and his master, which infuriated his master, Charles Stuart. And Stuart put slave catchers on him, and it took them over 2 months to find James Somerset in London, which at that time was the largest city in the world, really a teeming place. And they threw him on the decks. They chained him to the decks of a ship, the Anne and Mary, that was going to set sail for Jamaica, where Charles Stuart had ordered that James Somerset be sold in the slave markets, and then he was going to then harvest sugar for the 3 to 5 years that it would take to kill him, because everyone knew that a slave could only last 3 to 5 years before he died. So we don't know, and despite my attempts, I was unable ever to confirm the fact of who filed the writ of habeas corpus, because 100 years ago the legal office house cleaned out a lot of things, and one of the things they did is clean out this incredible petition for habeas corpus in one of the most famous cases in the legal world. But I still think it was his godparents, and they brought a petition for a writ of habeas corpus. And Lord Mansfield, who was probably the greatest judge ever to speak English, then ordered the captain of the Anne and Mary to bring in the body of James Somerset and give a legally sufficient reason why he was holding him. Of course, the reason that would be given would be that he was a slave. He was the property of someone else. And therefore, he could be chained and brought to Jamaica, and he could be sold. And that case went on off and on over a period of 6 months, which was an extraordinary time for 1772. That was at a time when the average felony trial involving a death sentence, including jury deliberations, lasted for 8 minutes. So the fact that it took 7 months to reach a final judgment was really extraordinary. And there were arguments on and off, and finally in June 22nd, 1772, which I celebrate on Facebook, I've never seen anyone else do it, Lord Mansfield then ordered him freed and said that the common law, he said that slavery was so odious, and he used the word odious, that the common law would not support it, and James Somerset left a free man. A stirring story, and indeed I do have a Hollywood producer and director who are working on making a mini-series of that. If you are a funder of Hollywood movies or miniseries, I will come up and see me later. I spent 3 years working on this because I intended it to be a metaphor for what the Nonhuman Rights Project was going to do, and also a blueprint for what the Nonhuman Rights Project was going to do. This is how a legal thing could use the judicial system and emerge a legal person. Sometimes I've called this move from thinghood to personhood a legal transubstantiation. You Catholics in the audience will understand what I'm talking about. So James Somerset comes to court. He looks a certain way. Eventually he leaves courts. He looks the exact same way. But as far as the law goes, he in no way resembles the man who walked in. He walked in a legal thing. He had the capacity for no rights at all. The law could really care less about him. It didn't see him. It didn't recognize him in any way, any more than it would recognize, an inanimate object, a chair, or the horse who he might have ridden in on. And so he walked out, though, a legal person, and he was a free man. And in fact, I start my book with him running down the streets of London to knock on the door of Granville Sharp, who was the first abolitionist of England. And that's how I know what happened, because he knocked on the door and Sharp recorded in his diary that James Somerset had come to him and said, "I'm free." And then this was, as Sharp then wrote, so reached the end of the long struggle between Granville Sharp and Lord Mansfield. Lord Mansfield did not know that he was in that struggle, but he did not know that 6 years before, Granville Sharp had decided that slavery was going to be abolished in England, and Lord Mansfield was going to do it. He accomplished it, and that's really the story of that book. And so this blueprint for the Nonhuman Rights Project was something that we looked at very carefully. We've had more than 120 folks from all over the U.S. working on this now for 7 years, not at all at one time. We usually have around 50 or 60 or 70 people working, and about half of them are lawyers, and the other half are scientists, we have lawyers and law students, law professors, there's about half. And the other half are maybe scientists, mathematicians, sociologists, media specialists, all sorts of people who are helping us really set the foundation for a long struggle. In fact, when I think about the struggle, and I think about this week, which for us was a watershed time, and I hope in legal history, I hope it's a watershed time as well. You know, I think of what Winston Churchill said when after the Battle of El Alamein, where the British finally beat the Germans in 1942, and he said in a speech that it was not the end, it was not even the beginning of the end, but perhaps it's the end of the beginning. And that is what we hope this week is, the end of the beginning. So let me tell you a little bit about the kind of arguments that we are bringing in front of the court. Which, by the way, we did have an argument. We had a legal argument that we lost on Monday in central New York, but we lost, but we didn't lose, because we don't think that a lower court, New York Supreme Court judge, is going to issue a writ of habeas corpus for a chimpanzee. We want the judge to say you lose on the ground that a chimpanzee cannot be a legal person, so that it's a nice, clean issue. We can bring it right up to the appellate courts, and then we can begin the real fight as to, based upon all of this evidence, all of the facts which are unchallenged, because there is no real opponent yet, so they're unchallenged, and based on the legal arguments that we are making, that indeed a chimpanzee can be a legal person with the right, the fundamental right to bodily liberty, the common law right, and that he can be freed, in fact he must be freed, pursuant to a common law writ of habeas corpus. Now, let me define a few terms. I already got habeas corpus. I want to get common law too, just so people understand what we're talking about. Many people don't. Many lawyers seem to get it confused as well. And so do judges. So there's different kinds of law. People know about constitutional law, and they know statutes. And so constitutions are written by constitutional conventions. Statutes are written by legislatures, the U.S. Congress, the Connecticut legislature, the New York legislature. But English-speaking judges are also used the common law. And the common law is the law that judges make. So they can be interpreting constitutions, they can be interpreting statutes. And in doing that, when they're interpreting a constitution, they oftentimes will be asking, well, what did the drafters of the Constitution mean? Or they might be interpreting a statute, and they'll say, what did Congress mean? What did the legislature mean? So they're always trying to figure out what somebody else meant when they enacted the statute. Unless it's absolutely clear in the statute, there's no ambiguity whatsoever, then they may not even ask what the drafters meant. They'll just say, it's so clear, we understand. But if it's ambiguous, usually a judge will then say, well, let's look at the legislative history, let's try to understand what was intended. That's not what the common law does. The common law is the judge is not interpreting what someone else has written, but they are making the decision themselves. In one of my books, I talk about the different kinds of common law judges. And I talk about some of them are very conservative, and what they do is that I call them formal judges, and what they do is that they look to the past. They think that the answers to all legal questions are found in the law library or on Westlaw, where you can do legal research. And so we don't want to go in front of those kinds of judges if we can avoid it, because there are no precedents that will really help us, and that a chimpanzee or another non-human animal has never been held to be a legal person. There are other judges, what I call substantive judges, who don't so much care about what's gone on in the past. I mean, they'll look at it, but they might care about public policy. They want to do what's good. They see justice as being good. What's good? Or principal judges, they see justice as being what's right, what's morally right. So you have kind of three different kinds of judges. One judge will say, we view law as a formal judge. We view justice as being certainty, stability. We don't care if the law is right or wrong, but the fact is that everybody understands that's what it is. And stability and certainty is our primary legal value. Then the two kinds of substantive judges, you have a policy judge who says, we don't really care what's gone on before, but we want to do what's good for society. That's what we think justice is. And then a principal judge would say, we don't much care about what's gone on before or even what's good. What we see justice as is doing what's right. And so we spend a lot of time trying to think about where we might find judges like Lord Mansfield who will do what's right, because we think that our arguments are not only legally right, but that they're morally right. And we want judges who, if they agree with us, will then rule in our favor, ultimately at the appellate levels. Again, a lower court judge is bound by what the higher court judges in his or her jurisdiction have done. And so it's unlikely that he or she will decide to step forward and be the first judge to say that a non-human, a chimpanzee, is a legal person for purposes of habeas corpus, until he or she gets some guidance from the higher courts. So that's why we're kind of going through the lower courts, understanding that we're likely to lose, but we're hoping that we lose on the ground that a chimpanzee, like any non-human animal, is not a legal person for purposes of habeas corpus. We understand that. In our oral argument, the judge was asked us repeatedly, are there any cases up there that directly support you? And the answer is no, there aren't any. There are lots of cases that indirectly support us or support something that is associated with us, but there's never been anyone who's ever claimed that a non-human animal is a legal person. To our knowledge, there's never been anyone in the English-speaking world who's ever made that kind of a claim. And it's only the boldest lower court judge who's going to say, what a great argument, you win. We're going to be putting up the transcript from our legal argument in the next few days, and look at the last paragraph. The judge said, what a great argument, you lose. Which was more than we were expecting, frankly. He said it was a great argument. He wished us good luck on the transcript. And he brought a stenographer in to make sure that everything was being recorded. So we understood him as saying, hey, you're bringing in front of me some really interesting arguments. I just don't, because I never seen them before and they've never been brought by an appellate court or they've never been considered by an appellate court in New York, I'm not going to rule in your favor. But we're doing what, I will help you preserve the issue, and we're going to get the issue up, and if you win, terrific. If you lose, you lose. And the judge also was taken by our descriptions of Tommy, who was a chimpanzee. He could see them, and he said on the record, as you will see, that we're not going to, I'm not going to declare that Tommy is a legal person, but if you can come up with any other way I can help you with Tommy, come back. I'll be your judge. So that was a good first try. And so that case is going to be going up on appeal, and that'll be the first court probably who will hear it. So in New York, there are 4 appellate divisions. the first, second, third, and fourth. And by sheer coincidence, because we have to file our suits in the judicial district in which our chimpanzees are being imprisoned, so that case was in the third, the case in Niagara Falls is in the fourth, and the case in Suffolk County was in the second. So we, by sheer coincidence, we have 3 cases in 3 different appellate divisions. So we're going to be bringing them up. We're going to have 3 cases that go up to 3 different appellate divisions, 3 appeals. And then we're hoping that, that we go then to the Court of Appeals, who will think that our suit is important enough to give it consideration. Now, what kind of arguments are we making? Well, we're making 2 sorts of arguments under the common law. Again, under the common law. We are saying, Judge, a chimpanzee should be a legal person. And again, what a legal person is, or maybe for the first time, what a legal person is a legal person is an entity that has the capacity for a legal right. And our very first section says, legal personhood is not synonymous with human being, because many people think it is. And we show that in 2 ways. First, we show that black slaves were human beings, but they were not legal persons. In England, until the Somerset case, in the United States, throughout the United States, until the 13th Amendment to the United States Constitution, I think 1865. I saw it in a movie. I think it was 1865, the 13th Amendment. I get all my legal information from movies. So, say again?
1865 was the Emancipation Book.
No, that was 1863. I saw it in another movie. So,
I got all my history.
So, wait a minute, I know, I always do this. I was talking about something.
You're making 2 points about personhood not synonymous.
Thank you. Okay. So, we showed from the one side that there were human beings who until the 19th century were not legal persons. On the other side, we show that even in the state of New York and elsewhere, there are non-human legal persons. Corporations, ships, partnerships, maybe counties or states. But of course, those are also kind of human-related things. But we show in other common law countries, and I think someone mentioned one last night, in 2012, there was a treaty signed between the Crown and the indigenous peoples of New Zealand in which a river was designated as a person. Then there was a case in the Indian Supreme Court in 2000 in which the holy books of the Sikh religion was designated as a person. There was a pre-independence ruling of an Indian court that a Hindu idol was a legal person. In other words, they could buy and sell property, for example. They could hold property. And so what we're saying, and I think it is true, is that a legal person is not a human being. A legal person is an entity that the legal system says is important enough for us to take notice of, and is important enough so that it can be a rights holder. So you can have, as I sometimes say, you can have a legal person is kind of like a rights container. It can be an empty rights container, but it's a rights container. And then you might have like a bottle of rights. In here are like millions of rights. So if you don't have the rights container, I can just drip my rights down and nothing's going to happen. But if a chimpanzee or other non-human animal or a Hindu idol or the holy books of the Sikhs, if they're designated legal persons, then what the judges are saying is that these are rights containers. Now we say, thank you, Judge. We now all agree that a chimpanzee has the capacity to have one or more legal rights. We're not saying he has any. We're just saying first we've established that he has the capacity to do that. Then we start, we unscrew our little bottle of rights. We say, Judge, the first right we'd like to discuss today is the fundamental right to bodily liberty. I drip that in. Can I drip that in, Judge? And that's where we have our fight. Can you drip it in or not? Can we, even though now we have a rights container, but does he have a right to bodily liberty or not? Fundamental common law right. So we have 2 major arguments. One of them is as a matter of liberty, and one is as a matter of equality. And we argue that alternatively, our chimpanzees should be legal persons with the fundamental right to bodily liberty that is protected by the common law writ of habeas corpus on these two alternative grounds. The first, as a matter of liberty, which is really saying that this is what we lawyers would call a non-comparative right. These chimpanzees are entitled to these rights without comparing them to anybody else because of who they are, how they're put together. Laurie Marino is going to explain to you in spades why that's so, and we're saying essentially these are autonomous beings. We have 150 pages of affidavits from these superb primatologists throughout the world who will show you that these animals are autonomous. They are self-aware. They can self-determine. They can make choices about how they want to live their lives. And the reason we're telling you about this, Judge, is we're going to show you the common law cases from the state of New York and some from the United States Supreme Court in which the courts say nothing, no right is more sacred than the right to autonomy. That's what is so important about us human beings, that we're not governed by instinct. We can choose how to live our lives, and that the courts feel it's their business to protect that. And we're saying, guess what? The chimpanzees live their lives in an autonomous way like we live our lives. And if you're interested in protecting the autonomy of those who are autonomous, that is human beings, but it's also these chimpanzees. They are also autonomous. And so the common law protection of autonomy in human beings can easily be transferred to the chimpanzees. In fact, what would species have anything to do with it? We're looking at a capacity, we're looking at a capability, we're looking at the ability to be autonomous, to live their lives. So we're saying, look, these animals are in these cages, they're by themselves, and we have arranged with the North American Primate Sanctuary Alliance to evaluate the chimpanzees that you release and have them placed in one of their sanctuaries. And at these sanctuaries will provide the best place that we have in North America where their autonomy will be respected. They will be as autonomous as they possibly can be in North America. We would like to bring them to Africa and just release them and say, so long, have a good life. Don't bother thanking us. We'd like to say that, but we can't because they're going to die if we just release them in Africa. At least we think that. So the next best thing we could do to effectuate their autonomy is to put them in a place where their autonomy will be respected to the highest possible degree. Because usually when someone files a writ of habeas corpus, as in the James Somerset case, you get out of jail and you say, and you're off and you can do whatever you want. But you can't do that with the chimpanzee. And we were able to look back into the history of slave habeas corpus cases, and we found 4 or 5 of them in New York and in Massachusetts, in which the courts had to deal with the problem, what happens when a 7-year-old child is freed through a writ of habeas corpus. There's a famous case called Commonwealth versus Aves, like the birds, in 1836, where the Supreme Judicial Court of Massachusetts had to deal with a little slave girl, Med, who was 7 years old, who was brought in because it was hot in Alabama, I think it was Alabama, and so for the summer, her mistress brought her to Boston. As soon as she landed, the Boston Abolitionist Society came in, brought a common law writ of habeas corpus. And her mom was in Alabama, but her mom was a slave. Her mistress was there. Of course, she was a slave, Med was. But the court found that she should not be a slave, that she should be released. Of course, you can't throw Med out into the streets of Boston. And so the court then said, well, we have to put her here, or here, or here, in someone else's care until that time comes where she doesn't need it anymore. She reaches majority. So that's what happened. And we're saying, well, our chimpanzees are never going to reach majority. They're never going to be able to be put out into the streets of New Haven. And because they'll be shot, in the next 15 minutes. But the place where they can go is to a sanctuary dedicated to them, and dedicated to allowing them to live as autonomously, as chimpanzee-like as possible. Now, when I started this 28 years ago, I never thought that 6 months before we filed suit that the National Institutes of Health were going to be releasing hundreds of chimpanzees. And not just for the heck of it, but because essentially they are autonomous. We have looked, we have studied their rulings. They talk about their ability to self-determine, how they have to be kept in mixed gender groups, how you shouldn't have a group of fewer than 7 chimpanzees. In fact, I had a person call me up and said, well, isn't your lawsuit a threat to the use of chimpanzees in biomedical research? And I said, the greatest threat to the use of chimpanzees in biomedical research is the director of the National Institutes of Health, which is true. But it shows it shows how far we've come in those 28 years. There's a sea change in how we view chimpanzees. The science, as I'm sure Laurie's going to show you, has been coming down and making it very clear that chimpanzees are us, and they are very close to us, and they have the autonomy that judges care about. Now, the second thing we're talking about is, or the second argument is, we're saying not just liberty, Judge, but as a matter of equality. And equality, we know, is a constitutional concept in the United States, but it's also a common law concept. And that the New York courts have accepted the idea of common law equality. And part of it means that you can't be treating someone in such a way that there's an improper end. When you're comparing two things, if you're saying they're equal, well, they're not equal for an invidious reason, because we are all infinitely similar to each other and infinitely different to each other. And when you're talking about equality, we have to choose among an infinite number of similarities and differences, trying to understand, well, which ones make any kind of legal sense to us. And you can have literally an infinite number of comparisons. And the New York courts say, as do other courts, is that if you choose a characteristic that really is invidious, oh, we're all equal, except, you're Jewish, I'm not, that's a difference. Well, yeah, it is, but it's not. It's an invidious one, and the courts will not recognize it. And we're saying, whoops, we're the exact same. Oh, you're a chimpanzee and I'm not. We're saying that, again, it's a distinction without a difference. Sure, it's a difference. There's a million ones. Hey, I have brown eyes, you have green eyes. Sorry, you're a slave now. And it's the exact same thing. They have the autonomy that means they shouldn't be a slave, and just because they're a chimpanzee, to discriminate against them simply because of their species, when otherwise they are so similar to us, is an invidious kind of discrimination, akin to racial discrimination or other kinds of discrimination amongst human beings. We're asking the court to recognize that. The judge in Central New York did not like that, because the judge, and I don't blame him, he didn't understand what we were talking about. He thinks we're comparing chimpanzees to black people, which irritated him. That's not what we're doing. It's not what we're doing. We're saying it's not what we're doing, and I don't have to explain it too much here. So, well, he made sure that went on the record. I think for his own reasons, he wanted to all of a sudden say, I find that offensive. Okay, but that's not what we're saying. I find it offensive too. Okay, so for that reason. Second thing is we're looking at the U.S. Supreme Court's case of Romer versus Evans, which came down 15 years ago now, in which Justice Kennedy said, by the way, it's part of the law of New York, maybe, obviously, that an amendment to the Colorado Constitution that essentially, theoretically could have stripped gay people of their rights violated the Equal Protection Clause of the United States Constitution. And Justice Kennedy said that choosing a single characteristic and essentially stripping someone of their rights based on that single characteristic violates every aspect of the notion of equality. And we're saying, again, look at the facts we're putting in front of you. We're saying that the difference between me and Tommy, who's in jail, in a cage in Central New York is that Tommy is a chimpanzee, and I'm not. You're taking a single difference, our species, and saying he's then not eligible for any right at all. And no, we're not comparing chimpanzees to gay people. I'll just try to preempt that right now. Though I'm sure I'm going to hear that. I'm sure I'm going to hear it. Not from my friends who are misunderstanding me either, I don't think. It's people who just, they don't like what we're doing. So that's the second kind of argument within equality. So we have a liberty argument, we have two equality arguments, the ones I just said, and they're all kind of wrapped in with the writ of habeas corpus, which says that if a being is being deprived of his fundamental right to bodily liberty, then he's to be released immediately. So in a, 40 minutes or so, I've kind of compressed the last 28 years and about 35,000 hours of work that the Nonhuman Rights Project has put into this so far. And I'd really like to invite you to ask me questions and we can speak about it, because there's nothing I like better to do. Yeah.